and assign inordinate importance to that language. And sometimes the language and different words are also used. Sometimes it is merely a stylistic device. And two judgments I'll just cite. One is a very old one, Crown versus Khushi.
Before you cite the judgment, I mean, on the one hand is the argument that you made. On the other hand, there is an argument which has been accepted by this court in a couple of cases that the words subject to the Constitution and subject to the law create a restriction that you can do everything unless it is prohibited by the law or the Constitution as it exists. दोनों को अगर आप हार्मोनियसली उसको देखें या उसको दोनों एंगल से देखें तो which interpretation to you is more appealing? आपने अभी पढ़ा आर्टिकल 67 again subject to the Constitution, उस पे भी ये interpretation कि ये restrictive है ज़्यादा plausible लगती है compared to attributing redundancy to it.
My Lord, what all I was trying to say is that if it had not said subject to the Constitution, it would nonetheless have been subject to the Constitution. Yeah. And perhaps not too much meaning need be ascribed or forced into it, and that's why I was just citing these two judgments.
Then why should too much meaning be ascribed to the and law bit of it?
My Lord, because the plain meaning...
Yeah, you can't have it one way.
No, because what I'm saying is that in a particular provision, it says that it will be subject to Constitution.
In a subject to Constitution, चलो हर कोई समझता है, और and law जो है उसको तो आप full entry 58 I mean surely.
No, well, my Lord, if I can...
कुछ तो rationalize कीजिए.
I'll just deal with that, sir. If I can just point out the judgments. Crown versus Khushi Mohammed, PLD 1953, Federal Court, page 170, at 174.
Which year is it?
53. 1953, Federal Court, 170.
What is the proposition?
At page 174. That sometimes this distinction in the words used is merely there for stylistic reasons, and there is not a clear legislative intent.
But is that
to
your
mean
point,
things.
that this is stylistic?
The subject to
Is stylistic.
Constitution.
And law, not law.
No, because
Constitution is stylistic, law is not stylistic.
No, because my case is that the subject to the Constitution is there all the time, whether you say it or not. Sometimes they say it, sometimes they
So
don't.
you are saying it will have to be read in context.
Yes.
Sometimes these words, unless some case comes in and those words become critical, then they have to be read in context.
Yes, exactly.
Simply put.
Exactly. But when they have specifically added something more, which is not always understood. Sometimes, for example, constitutional rules might stand on a higher
ये जो आप
footing than
आर्ग्यूमेंट कर रहे
statute.
हैं, ये आप स्टाइलिस्टिक है. This is in the context of wherever it is used subject to law in the Constitution, or are we now going to say 191 में stylistic है, but Article 14 में stylistic? How do we read that then?
It was specifically in response to my Lord's question that why is this word subject to the Constitution used when it's
नहीं, अब तो subject to law पर आ गए हैं ना.
जी,
So
मैं subject to law के हवाले से मेरी गुजारिश ये है कि an addition is made, because that is not something that is automatically understood, because there can be rules with constitutional backing that do stand on a higher pedestal than statute. That is a possibility. But as far as the rules made under 191 is concerned, the addition of the words and law when compared to other kind of constitutional rules, that is a significant difference.
Kindly take a look at Article 99.
Ji, the federal government's...
Yes. Kindly take a look at Clause 2 as it stands now.
The federal government shall by rules specify the manner in which orders and
You don't
other...
have to read the rest. Now, here again, direct rule-making power conferred by the Constitution on the executive branch.
Yes, sir.
Obviously subject to the Constitution, but not subject to law. I'm asking you.
Sorry, yes, of
Not
course,
subject
subject to the Constitution.
So, where the executive branch is concerned, we are to say that the rule-making power is on a higher pedestal, even though under our parliamentary democracy, for example, federal government is collectively responsible to the National Assembly. In fact, the Prime Minister and so on, they arise out of Parliament itself. It's not a presidential form of government, it's a parliamentary form of government, Westminster style. So there, the executive branch is put on a higher level, that even though they arise out of and are answerable and accountable to Parliament, in their rule-making power, they can just ignore any law. And that, in fact, Supreme Court can't, although it is a separate branch of the state, Supreme Court, because law, you say, is an enabling power, and therefore the Supreme Court is not the master of its own house. The master of the roster is Parliament.
My lord, I wouldn't say that they're master.
Is this a constitutionally viable argument?
I wouldn't say they are master of the roster, the Parliament.
You have,
because-
I asked you, you specifically have said, law can repeal the Supreme Court rules.
Yes.
What more is there left?
Yes. That doesn't automatically, my humble
No,
submission
that's
is.
a matter of competence here. What more is left?
My lord,
They can say, we throw out your rules, 1980, so that's like 43 years standing rules. We throw them out. Out you go. We make our own law. We are the master of the roster. And in our rule-making power, we empower the federal government to do whatever we wanted.
that, if they did that, my lord,
It's
my,
आप देखिए ना, this level पे, at the highest level, committee, no committee, everything, they are, and I'm going to use something very strong, but I'm saying it with all deliberation. This argument reduces the Supreme Court. All due respect to Parliament, it reduces the Supreme Court to a hapless plaything for Parliament. This surely cannot be right.
Lord,
This surely cannot be a constitutional interpretation. What would you say to
my
that?
lord, I would humbly.
Please don't say that it can be a hapless plaything of the Chief Justice. Don't say that.
Salahuddin, I think I beg to differ with my learned colleague on the Parliament being the master of the roster. It could have been, had the Parliament kept that power with themselves.
Yes.
Had the members of the Parliament been in charge of this, yes, we could have said that they've become master. They've actually left it to us. So instead of saying that the chief is the master, they're saying 6 people or 3 people or 5 people are the master. So it's not them. Had they retained it with them, then they could have. one could probably say.
Choice is ultimately theirs. That's the problem.
My lord, with
There is
respect,
very-
I look at
Committee
it.
is the
Salahuddin,
creature of Parliament.
I
If they
think
can do
creation of
this,
Parliament.
if they can do
There's a
this, and
justification.
we say that you can do this,
There's
then
a-
they can do that also.
Tomorrow when they do
That
that,
is
we'll
the
strike it
I'll
down.
address this, I'll address
Every,
this.
every law also has to be seen in its historical context. The master of the roster and the powers exercised probably were viewed by the representative of the people to have been exercised against their interests. So that is why there was a need for the law. And we cannot ignore or just turn a blind eye to the historical context of why it was so necessary.
And somehow
My lord,
we
there
sort of
has to be-
referring to the Parliament in a bit of a derogatory sense. You see, as if they're the Indians or some people outside somewhere. You see, it's the Parliament, and Parliament is a house which represents the people of Pakistan. So people of Pakistan, through their representatives, cannot have a right to say how the Supreme Court has to function. It is, we are trustees doing work for the people of Pakistan. They can't turn around through Parliament and tell us how to regulate things. So even if the word dictation was used, I would say, yes, people can dictate how we're supposed to do. I mean, who are we? We're just
The
trustees.
people can dictate.
It is
the
not
government
just
can't.
the voice of the people.
But the Parliament are the chosen
And the
representatives
people have
of the
already
people.
spoken in
It is
terms
not,
of the
it is not
Constitution.
just,
So if the people want to speak again, Obviously, people have given the constitution. Let them say so in the constitution.
make
32 or 34 MNAs sitting in the parliament, they don't speak for the people. They speak for a party for the reason that the majority is the government actually. So it is rolled into one. The executive and the parliament are rolled into one.
Speaking
If-
for myself,
If
let us not.
if the people of Pakistan have to have their will, yes, it is their country. They have given the constitution. They have a right and they have the power to amend it. The moment they amend it, the entire argument finishes.
Hello.
आगे बढ़ें.
I just wanted to say to.
You concluding now?
Just 10 minutes. Sir.
Ji.
As far as this is concerned, just to wrap up the relative primacy of statute and rules, my submission would be that no doubt that the two spheres, legislative competence and infringement of judicial independence, those are completely separate issues. So if Parliament has legislative competence to even completely repeal and modify and bring in new Supreme Court rules, it will nonetheless
Will it not be subject to anti-55?
Sorry, sir?
If they legislate a new law, the parliament, will it not be subject to anti-55?
As far as creating additional jurisdictions is concerned, yes. As far as practice and procedure is concerned, my submission has been that it doesn't depend on NT55. But what I'm saying is that if Parliament does repeal the Supreme Court rules, it brings in its new rules, your lordships will check those rules on the touchstone of Article 10A. And if there's anything in those rules that effectively impairs your lordship's independence, then your lordships would be free to strike it down. It is, for example, sir, that Parliament has competence to pass any criminal law. But if Parliament passes a law that anyone who looks at us funny will be hung, your lordships would not examine the case on the basis of legislative competence. Your lordship would strike it down as being contrary to Article 9 and so on and so forth. So those two aspects have to be segregated. Now, if to move on, sir.
So you mean that door can be open, but scanner has to be installed?
Yes, if the opening of the door is misused, then your lordship can step in. Now, as far as independence, that brings us to the independence of judiciary, sir. It is exactly, and the opening of the door, jo provision, as far as I understand it, it's very different from legislative competence. Let's say a law seeking to regulate a trade is challenged on the touchstone of Article 18, or a law imposing a property tax is challenged on the touchstone of Article 24. This court will not say that, oh, if we open the door, tomorrow they might take away all the property, or tomorrow they might prohibit in the guise of regulation. Your lordships will examine the substance.
Yeah, rather than going into vague examples, what this law does not do, which is significant, I don't know if I've noticed it, its significance or it's not significant, is we have this whole concept of mandatory and directory provisions. Now, this law does not stipulate anywhere whether consequences of not strictly abiding by it. So maybe Parliament, in deference, did not say maybe the next step, any case so decided in contravention will be considered quorum non judice or something. They could have done that. Then it would have become a mandatory. That's my understanding. I may subject to correction. Here it still has left room, whether we call it wriggle room or whether we call it interpretation of the three senior judges of the Supreme Court. It's not taken away everything, because there's no consequences that, okay, there may be situations where it's not practical or feasible or for whatever reason. And I don't know, I don't want to kind of envisage all these situations. I have this law before me. It does not clearly stipulate that if you don't strictly abide by each and every letter of it, there are adverse consequences either for the judge or it constitutes misconduct or something like that. So nobody has touched upon this point at all. And everybody is assuming that it is extremely mandatory with grave consequences if not abided by. Now, if we take a sort of a middle ground and say, yes, it is not mandatory to that extent, but it is a law and you would, I mean, like so many laws say, take the Anti-Terrorism Act. Has it ever been abided by? Trials completed within 90 days. NAB, I think, law says the same thing. Now, is the judge removed? Is the judge sent into jail? Is he disqualified? Trial continues. I mean, you know, that's kind of, you know, showing the beacon, the light, okay, this is what you should do. But many times it's not done. In fact, under those laws, I have not come across a single case where they have been strictly abided by in terms of time. And Parliament has always, throughout, in various statutes, fixed timelines because they want presumably people's issues decided quickly. But they cannot be without prescribing the consequences. So absence of consequences, nobody is touching upon. Do you have anything to say on that?
Lord, I would submit that ordinarily, of course, one would expect your lordships to follow the law that has been
there is a very serious consequence. Even if each and every provision of this law is, other than the appellate provision, maybe the practice and procedure part is read as directory, and the 3-member committee says, well, out it goes, we don't care, we are not going to follow it, will they not be in breach of their oath of office?
Lord,
the oath of office says they are bound to act by the
I wanted to hear something from you.
And
I mean, it can be the bloody-mindedness of the Chief Justice or of all three of us.
That's, even if it's directory, it's directing judges who've taken an oath of office. Then are the judges going to say, well, this is not law and we won't abide it?
न्यूज़ स्टूडियो से अब तक के लिए इतना ही। देखते रहिए ABN न्यूज़, क्योंकि हम हैं कौम की सोच।